I'm just conscious of time. You know that the Supreme Court is managed on a regulatory framework.
Yes.
What are the challenges, if any, that when you look at the Supreme Court, it has in its regulatory framework? And there have been proposals over the year that there needs to be some constitutional amendments to the structure of the Supreme Court, including to increase the numbers of the Supreme Court, to bring a limited term to the Supreme Court, for Supreme Court judges not a 10-year term, because it's such a political court. This issue you are discussing with Justice Mirima, whether you can leapfrog certain issues like constitutionality of statute, that perhaps it should leapfrog from the High Court to the Supreme Court, and also the budget of the Supreme Court, that in other Supreme Courts, they have an independent budget, and that's not the case here. What is your comment on these kind of amendments? And do you have anything else that you would look at the regulatory framework and say, this is the direction in which the Supreme Court should do, and if you come to the Supreme Court, that you'd be able to support such change?
Okay, so the question is more administrative than legal.
Yes, we have now moved from legal.
Okay.
We are still an institution.
Yeah.
We have our administrative issues.
Yes. I think the other suggestion also was to ask that the Supreme Court the number of judges should be increased from 7. I think that's one other suggestion.
Oh, and one final, yes, that the number of days to listen to the presidential election petition should be increased. What do you think of that?
Okay, so I'll just answer from my feet, because it's not something I've really thought about. I know the discussion has been more in the nature of the numbers of the Supreme Court number of judges. But then your question would be on the leapfrog. I think I maintain the position I took in my conversation with Justice Murima, being that the Supreme Court is one more set of minds on an issue. And it is better if by the time it is scaling to the Supreme Court is able to look panoramically at all the thoughts that have gone into the issue, and to be able to adjudicate and give directions. And so I would still restrain myself from saying the leapfrogging would be a wise thought. On the issue of 10 years, yeah, probably it's a good idea. And I'm just answering this on my feet, my lady. It's not something I have thought. The other option is probably to do what ICC does. The ICC doesn't have so the ICC has 3 levels. It has a pre-trial level, it has a trial level, and it has appeal level. But there are no trial or appeal level judges. What happens is they rotate. So that you would be today a pre-trial judge, next month or probably after a term of 2 years, you move to the appeal level, then you come back to trial court. That's probably another consideration, so that the term doesn't need to be 10, but And the difference then in the ICC vis-a-vis Kenya would be, the difference is the number of mines, because if a matter is being considered at trial level by 3 judges, when it goes to the appellate level, it is 5 judges. So the difference is the number of mines rather than the seeming, it's not a question of cadre, rather, it is the amount, the volume of mined material that is applied to the issue. So instead of the 10 years, probably my thoughts would have been to consider a possibility of having a rotational situation. On budget, I think that would be creating too much class. I know this probably is unpopular, but I think if the Supreme Court was to have a separate budget from the rest of the judiciary, then it would border on a statement saying this is a special court and it's not part of the judiciary. I would rather that they remain part of the judiciary. I hope I have answered your questions.
That's enough. Thank you very much. That's all, CJ. Thank you.
Thank you, Chair. Good afternoon once again.
Good afternoon, Your Honor.
I hope you're not tired. It's been a long day.
I am okay. I'm okay.
Okay, so you are now a member of the bench.
Yes.
And so when we are to evaluate your performance, it has to be evidence-based because we have a system for measuring that. But unfortunately, I find myself a bit handicapped. I have your report here from DISPOP, which basically captures data on the benches that you have sat in since you were appointed as a judge of the Court of Appeal. I think that's hardly 3 months now.
Yes.
Is it?
Yes, yes.
I think it's about 3 months.
Yes, Commissioner.
Yes, so there isn't much I can engage you on, save to say that you have some non-merit resolutions in the benches that you have sat, and you have had just a few sittings in the Nairobi Civil Appeal Division, the Criminal Division, and also Nyeri Court of Appeal. I heard you mention, though, that you have done one merit resolution.
Yes, so let me explain that. I'm yet to get quite familiar with the terminologies, but this is the scenario in terms of performance. I have served in terms of being on duty, and I think that's fairly routine. I have also sat on single judge matters, and I can say this for a fact that I have no pending single judge matter except the ones that were listed, that were coming up today and yesterday. And those ones are scheduled for delivery next week. And so for those ones where I am fully in charge, I have nothing pending except those ones of yesterday and today because I was in the course list. In respect to the others, as you appreciate, it is collegially, you have to do the draft, to circulate, get approvals. And so those ones are still going through the circles. I think my first ones would become due from mid-May. Okay. Yes.
Okay, maybe then we can discuss something else.
Yes.
As you probably know, performance measurement has had a long history in this institution. We came from a period when we were violently opposed to the idea of measuring a judge's performance, to where we are now, where we have a framework that does that. Now, what I want to ask you is whether there is a legal framework underpinning the need to measure performance in our judiciary. Do we have a legal framework?
Yes, I would say I would refer to the Constitution and say the need for transparency, the need for accountability to the public is such that it should be possible to evaluate and determine whether taxpayers' money designated for judiciary is value for money. And I would anchor my contention on the need for performance on the requirements of the Constitution that there is need for accountability, financial probity, and and performance. I would also say that the requirement that that would be my argument. I would say performance is anchored in the need to be accountable to the public.
Yes. Okay.
Yes.
Sorry. You're done?
Yes.
Okay. And there's also the Judicial Service Act, Section 5.
Yes.
That requires us annually through the Chief Justice to give a State of the Judiciary and Administration of Justice report.
Yes.
Which basically, of course, stems from the performance measurement that we do.
Yes.
Now,
I probably just wanted to say this, but I wasn't sure whether I should say it or not. But let me just say it now.
I thought you wanted to say it, yes.
Yes.
You started
I think there is
the
the pending question of quantity versus quality. I think it's something that probably still needs attention. The criteria for determining that the amount, the statistical return on the numbers is not enough, that there is also need to determine the quality of the output. I just wanted to put that additional comment.
Okay. I thought you said you wanted to talk about Section 5 of the JS Act.
I also wanted to say that.
Okay. So the arguments that we had as we were developing this concept in the judiciary was the fear or the concern that this would sort of interfere with the independence of individual judges, because as a judge or as a judicial officer or anyone discharging judicial function, you are supposed to do the same without fear, favor, or any kind of pressure or direction. Now, in your view, are there any safeguards against interference with the independence of judges in the current framework that we have? If you have any, you can mention them. And the second limb of my question, where then is the balance between measuring performance and safeguards, if there are any?
The only argument I would make around that issue is I have no doubt in my mind that there is need to measure performance, and there is need to require the judiciary to demonstrate that they have delivered on it. I have no doubt about that. I think it's the question of how you balance the intricacies around it. And I would think the conversation should be more in saying, are the targets placed on the judges and magistrates too onerous to a point where, in consequence, they look more at making determination even where quality could be sacrificed so that you meet targets. So I think the conversation should be more whether the targets have been balanced in a way that it doesn't place pressure to a point of diminishing the quality of the work done. I would think the conversation would be more there than whether or not there is need for performance. And that's where the balance, I think, needs to be placed.
Okay, that's where the balance, but do we have any safeguards in our laws, maybe statutory,
yes,
or even constitutional,
yes,
to protect or to safeguard the independence of the individual judges and judicial officers vis-a-vis measuring their performance?
Yes, the general proposition that they have judicial independence, I think, is, and the fact that judicial independence right is protected in itself, I think, is the countermeasure to ensure that. And then probably a little more on the judges, also the security of tenure, the process of recruitment, and the budget arrangement for the judiciary. All those, I think, give some level of cushion to protect the judicial officers and the judges.
Okay, thank you, and I wish you well.
Thank you very much.
Thank you, Honorable Chair. Honorable Judge, I know you've been on that seat for too long, yes, but don't worry, we're about to finish, so my session will not take too long. And now, please address us on the tension between judicial independence and judicial accountability, and tell us how the tension is managed at the level of the Supreme Court, where there is no higher court or where there is no further appeal.
Judicial independence and judicial accountability, I think, is probably the conversation we've just had with the previous interviewer, being the need to arrange so that the judiciary is not such that it is a castle, it is a law unto itself, but is accountable to the public. And so, to my mind, it's a question of just balancing that in the quest to ensure that there is delivery of services, pressure is not placed to a point where the quality of work is diminished. But that independence is necessary and accountability is necessary. And to the extent that your question is the tension is that my view is that they have to coexist. So somehow they have to find a balance because both of them are necessary to be to the taxpayers. In terms of the Supreme Court, I think the quality of the work done, I should imagine also that they also have policies on targets of what they are supposed to achieve in terms of timelines and things like that. And I think that still takes care of any concerns that they are not accountable to anybody. But importantly, I think they are accountable in terms of the need to present the state of the judiciary, the need to make presentations to Parliament, the need to justify budgets, and also the public, the access of the public to see their performance is a countermeasure that ensures that the Supreme Court delivers on its mandate reasonably, within time, and to the quality.
Okay. How has the Constitution provided for the independence of the judiciary?
So the independence of the judiciary in the Constitution would include issues like what we are going through, the procedure for recruiting judges, that it is open and public, and the evaluation of the competence is merit-based. There is security of tenure. There is separation of the budget for the judiciary. Those ones come to mind immediately.
Okay, thank you. I'm satisfied. I'm satisfied with those.
Thank you.
The final question for me, I have looked at your choice of referees.
Yes.
You're positively and highly recommended by the referees you provided. And indeed, I can say you know people. So now, given this as a judge of the Supreme Court, if you are to receive a phone call or a message from a senior state officer in regards to a matter that is before the court, how would you go about that situation?
Okay, I would do what the law requires me to do. I would apply the law to the facts, and it doesn't matter what message or call I have received. I would remain faithful to my calling and to my oath of office.
Would you honor that engagement?
No.
Or discussion?
No, I wouldn't.
Okay. Thank you, and I wish you well, Judge.
Thank you too.
Thank you, Honorable Chair, and welcome again, Judge.
Yes.
Yeah, I have two questions for you. Very, very brief. Now, the judiciary is increasingly adapting digital systems such as e-filing, virtual hearings, and automated case management platforms. While these reforms promise efficiency gains, they also raise concerns about digital exclusion, cybersecurity risk, and over-reliance on technology vendors. How should the Supreme Court guide the judiciary in balancing technological modernization with constitutional guarantees of access to justice and data protection, especially for vulnerable and digitally marginalized groups?
Okay, so thank you. I think it's a question of continuously being diligently conscious of the environment we are in, and always looking out to make sure that some segment of the population is not left out. And in that regard, I think the concept contained in the START is a very useful one, because it endeavors to reach those ones whose access to technology and whose geographical locations may be so far flung off to a point where they might be excluded from the judicial process. So I would think that the Supreme Court, where occasion arises, would also encourage those that kind of enterprise containing the statute, the ADR and the AGS. On the technology, on cybercrime, I think it is also a question of diligence, remaining very vigilant to make sure that the technology deployed are up to date to a point where it doesn't expose the judicial functioning to the risk of cybercrime and hijacking and frustration.
Okay.
Yes.
Now, in circumstances where a constitutionally sound decision is likely to be unpopular and could create or trigger a political backlash, how would you uphold integrity, impartiality, while maintaining the court institutional legitimacy?
Okay, I understand the question, Commissioner, to be what I would do if there is a, what did you?
There's a case before you.
Yes.
And the decision would actually trigger a political backlash. So how would you maintain or even uphold integrity while maintaining the court institutional legitimacy? The decision
Yes.
might likely
Yes, I
be
got the question.
unpopular. Yes.
Yes. You could even replace that by saying the LGBTQ case. Okay. My view of it is that it just calls on the judges to make sure that they reflect deeply and profoundly on what the issue is, and make sure that the judgment speaks for itself, to the extent that anybody who is honest about it looks at it and says in good conscience that indeed the output from the reasoning of the judges is what the law says, and it doesn't matter that it is unpopular. What matters is that the law has been applied, and I can think of a number of cases like the LGBTQ case, the issue of CTF. The judiciary had to deal with adverse view, but I think the quality of the judgment, the way the judgment speaks for itself, speaks well for the judiciary, and helps therefore to maintain the integrity of the judiciary and the perpetuation of the judiciary, being faithful to the calling and being diligent in the work.
Okay. Thank you. I wish you all the best.
Thank you very much.
Yes, good afternoon again.
Good afternoon, Vice Chair.
Yes, I know it's quite long, but almost through with it.
Thank you.
Now, on global issues, how does globalization affect constitutional law?
Globalization affect?
How does globalization affect constitutional law?
Constitutional law. Yes. Okay, so globalization, thank you for the question. I think globalization affects the constitution in the sense that even when you have the law, the constitution in place, issues of other jurisprudence come in, and you keep needing to cross-reference it to the constitution. And for instance, the case of BBI stands out very prominently on this, that the constitution is there, it has provided for how it is to be executed, it provides for how it is to be amended. And then an argument is introduced on basic structure. And so you can see immediately the globalization is already integrating with the constitution. And so in answer to your question, yes, the globalization affects the constitution, and the function of the judiciary is to be always on lookout and borrow what is possible and reject what is not in tandem with the constitution. And sometimes see the extent to which they can coexist. That would be my answer, Vice Chair.
How can the judiciary benefit from global networking?
I think it would benefit, first of all, in manpower improvement. The network could be such that knowledge is received and is passed on between the involved parties in the network. I think it would also help in terms of, so that would be, first of all, personnel capacity. There would be also resource input from partners, and I would think of those two as the important outputs, and also the hybrid of the law that comes then from that kind of integration and relationship.
Thank you. Thank you, Honorable Sija.
Thank you, too, Chair, Vice Chair.
A microphone, sorry. Thank you very much, Commissioners and Judge. I believe you are very tired by now.
I'm okay, my lady.
But we are about to complete. Just one clarification from you. When we called out for the applications, there was a list of documents you are supposed to provide. We called for these applications. The advertisement was on 13th January, and it was closing on the 17th of February. And we give instructions on how you are to apply and the documents you provide. The list of documents are many. You provided others, except you did not provide a current declaration of income and liabilities as at the making of the application using the prescribed form. What you gave us was the previous declaration you had made for the Court of Appeal, which is dated income for the period 20th January 2025 to 31st December 2025. You are
my lady,
supposed to
do I have your
fill in-
permission to refer to?
To refer to the...
I have a copy.
Yes, I think that's the one I'm also referring to, the one you filed.
Yes, which page, my lady?
The one I have, show him. Yes, you have seen what I meant, that you are supposed to, when you were making the application, you were supposed to fill in that form for that period when you were applying.
Yes, my lady. I have been shown by the registrar. As you can see, the declaration is dated January 2026, I think, which is the date it was filled. And the status of the assets between the time I made the previous application and the time I made this application, the assets have not changed. And so that is the answer I have for that. Secondly, my lady, is that my understanding of it is that the world declaration intervals would be after 2 years, and but the declaration I had already made, I had labored under the impression was adequate to that extent. So those two reasons, my lady, that the assets had not changed, and secondly that it was still within the time of my last declaration.
Yes, you see, this was a requirement for the application, for every applicant.
Yes, my lady.
To complete that form, even though you had completed earlier, you should have just completed and said the assets are the same, completed and followed the instructions as per the advertisement.
Yes, my lady. My understanding is that I'm in compliance, although I stand to be corrected. My understanding is that I'm in compliance to the extent to which to the extent to which I've just explained in the answer I've just given, my lady. Let me not belabor the issue.
Very well.
Thank you.
So I think this brings us to the end of the interview this afternoon. Sorry it has been drawn over the time that we had dedicated, but I think the commissioners who are interested in proving your suitability. So this is the opportunity we give you also to engage us.
Thank you, Chair. I just want to say thank you very much for finding me deserving to be shortlisted, for the opportunity to appear before you, and for the courtesy you have extended to me in the questions asked. I want to say thank you very much and wish you well also in the process of doing the evaluation and determining the suitable candidate. Thank you very much, everybody.
Okay.
Yes.
On behalf of the commissioners, we also wish you well, and we wish you success in all your endeavors. We will get in touch with you when we complete the exercise.
Thank you very much.
Yes,
thank you, everybody.
We are now releasing you.
Yes.